Welcome to the WRAL Daily Download. I'm Jack Hagel. The U.S. Supreme Court will hear arguments tomorrow in a pivotal case out of North Carolina, and we've been digging into it this week. The case is Moore v. Harper, and legal experts say it could have wide-ranging ramifications on election laws across the country. For an overview, be sure to listen to yesterday's conversation with WRAL state government reporter Travis Fain. Today, we go a little deeper on the arguments, on both sides of the case. We extended invitations to North Carolina House Speaker Tim Moore and State Senate Leader Phil Berger. They're among the Republican leaders who brought this to the Supreme Court. They declined our invitations, but we will hear from a representative of the state GOP. Later in the show, we'll speak with Bob Phillips of Common Cause North Carolina. That group opposes the Republican leader's effort. We'll also hear from WRAL state government reporter Bryan about the amount of outside interest in this case. We're going to start with Michael Whatley. He's the chairman of the North Carolina Republican Party, which filed a brief in support of the Republican leaders in Moore v. Harper. Michael, thanks for joining us today.
Glad to be with you.
There seems to be some disagreement on scope here. Some say this case could herald the end of American democracy, while others say that's a bit overblown. When people ask you about this case, how do you describe it?
It's a pretty simple case. It basically is the Constitution of North Carolina says that the legislature shall draw maps. And it says that the legislature shall control, basically the times and way that we run elections here. So they draw the maps. The Supreme Court threw out those maps, and the courts came back and drew maps themselves. We don't believe they have the authority to do that. So it's a fairly simple case of whether or not the courts have the authority to draw maps, which we don't believe they do, as we're moving forward.
So this is just specifically on that issue, just about time and place and manner of elections.
You got it.
Now, some argue that this case could be bigger than that it could weaken checks on the legislative branch, but the GOP contends that there's already a check on the branch, right?
Well, there is a check. I mean, and the courts have the authority to review the maps. They have done that multiple times, God knows, over the last 25 years here in North Carolina. And I don't think that anybody is disputing whether or not there is a review. But they do not have the authority to replace the maps that are drawn by the legislature with their own.
And there's a broader check, the electorate.
Yes, absolutely. And every 10 years, we're supposed to draw new maps based on the census. So, if there's a reason to interfere before that, then you can certainly do it. And we have seen, so many maps because we've had such an activist court over the last 20, 25 years. It will be very good to be able to put this issue to bed and have a statement from the U.S. Supreme Court that it is the legislature who needs to be able to draw the maps.
Redistricting disputes aren't new, and on top of that, cases in the coming years could actually be favorable to the GOP in North Carolina. The state Supreme Court, after all, will have a Republican majority starting next month. Why do you think the state's Republican leaders thought that now was a good time to take this to the highest court in the country?
Because the courts drew their own version of the maps. I mean, that is really the incident that caused this thing to be appealed. And I agree with the thinking by the legislature, that they are the ones who are supposed to be able to draw the maps, that the North Carolina Supreme Court acted outside of its authority, and this is a very ripe issue for the U.S. Supreme Court to take up.
Now, depending on how broad this ruling ends up, this case could ultimately strengthen any legislature's role in election laws. So in theory, we could see laws in blue states that are more favorable to Democrats, right?
Conceivably, you could, but I think that the particular question comes down to the North Carolina Constitution and North Carolina law and how this Supreme Court has applied that. So, yes, conceivably, the Supreme Court could expand beyond that and have implications in others, but generally the Supreme Court wants to narrowly tailor their decisions to the facts that are in front of them. So I assume that is the direction they'll go.
Now, election laws are inherently partisan. They're proposed by partisan lawmakers. They're approved by partisan bodies. Now, unaffiliated voters in North Carolina sort of outnumber all voters in the state, and one might assume that they just want the partisan part to be when they cast their ballot. Is there a way to make the process of defining elections, where and when and how they're done, more nonpartisan?
No. I mean, and the thing about it is that no matter who is making these decisions, it is an inherently partisan process. It's an inherently political process. And you may be able to get some of the partisanship out of it, but you'll never get the political out of it. And the U.S. Supreme Court ruled just a few years ago that, they specifically said this is an inherently political process, and it is not for the courts to decide. It is for the state legislatures.
So you're going to be listening to the arguments tomorrow. What are you going to be listening for?
I think what we want to listen for is the questions that the justices are going to be asking for the conversation to be focused on North Carolina law, on the North Carolina Constitution, and the facts that are going to be in front of it. And we feel that the arguments are really very straightforward in this case.
Is there anything in this case that you feel like has been maybe undercovered or an aspect to this that you think deserves more attention?
Look, I think a lot of people have put a lot of arguments out there talking about, the dramatic ramifications of this particular case and what it could mean for every state or for every map. We don't see it that way. We see this as a very narrowly tailored case dealing with specific facts on the way that the North Carolina courts drew the maps when they don't have the authority to do it. So as we're kind of watching what the national discussion looks like, we don't see the sky is falling here. What we see is a narrow tailoring of the facts. And we hope that the Supreme Court is going to basically come in and say that when the plain language of the North Carolina Constitution says that the legislature shall control, the way that elections are going to be run, that's what the Constitution means.
So that's your hope. What is your expectation of?
I think that's where the court is going to go. We have seen any number of election law cases over the last several years where this court has basically said that this is an inherently political process and it needs to be left to the legislatures, and they need to be able to follow the state constitutions and the state laws all around the country.
Well, lots of eyes on this one. Michael, thank you for being with us.
No, thank you. It's a great story. It's a great case, and we're excited about it.
That's Michael Whatley. He's the chairman of the North Carolina Republican Party. We'd like to add that Senate Leader Phil Berger issued us a statement. It comes from spokesman Randy Breckbiel. It says, quote, "This case is about state courts in North Carolina taking control over the drawing of federal congressional districts. The congressional districts used in our election last month were drawn by state courts, despite the fact that the U.S. Constitution states those districts should be established in each state by the legislature thereof. Legislative leaders are seeking confirmation by the U.S. Supreme Court that the Constitution means what it says, and an end to 11th hour judicial gerrymandering of federal congressional districts by the state courts. This case has no bearing on the role U.S. Congress or federal courts have over congressional redistricting." End quote. We'll take a quick break. When we come back, we'll hear from the other side of the argument. And after that, we'll hear from WRAL state government reporter Bryan Anderson on the outside interest in this case. Stick around. Welcome back to the WRAL Daily Download. We're talking about the Moore v. Harper case that will be argued before the U.S. Supreme Court tomorrow. In this segment, we're joined by Bob Phillips. He's the executive director of Common Cause North Carolina. Common Cause is a respondent in the case, meaning they oppose the Republican leader's argument. Bob, thanks for being here.
Thank you, Jack. Good to be with you.
This ostensibly is a redistricting case, or is it something more than that?
Well, a lot of people think it is something more than that. It is out of a redistricting case, Harper v. Moore, not to get too confused. But that was the litigation we were a part of, a plaintiff in that case, challenging the congressional and legislative maps that were approved by the legislature in late 2021. The concern is that this decision, whenever it comes in June or July, would perhaps, if it goes the wrong way, from our point of view, would mean more than just redistricting. It could essentially provide the legislature authority to pass voting laws regarding our federal elections unchecked.
So for a little bit of background, in North Carolina, like a lot of states, the party in power at the state legislative level draw voting lines, and that determines where people vote, voting districts and so forth.
That is right. When Democrats were in charge, they ran the process and they gerrymandered, and Republicans gained power in 2010, and they have been doing it ever since.
So supporters of your cause say that this ruling could upend democracy as a whole. One, is there any merit to that? And two, why do they say that?
Well, of course, I believe there is. I mean, how in the world can you allow a legislature to gerrymander, rig districts, and it be legal and get away with it. I mean, the court has always served as the place to seek relief, and in this case, we successfully challenged the congressional map as a partisan gerrymander. The court agreed with us, and so that's the danger. I don't think anyone really thinks that rigging lines for the entrenching a particular party in power is a good idea, except for the lawmakers who actually do it. And this case could take the state Supreme Court in North Carolina and all the states across the country. It could remove them from having any ability to review maps. It would completely dismantle the checks and balances we've had since the founding of the country. And you're removing, in this case, the judicial branch's check on the state legislature. And it doesn't make any sense, any logical sense. It's sort of what we call anti-originalist, in that this is not what the framers had in mind. And we've never really had the state Supreme Courts in any state removed from this review of election and redistricting. And this is what now the plaintiffs are trying to suggest should be proper.
The Republican leaders of North Carolina, the applicants in this case, they say that this case is much more narrow than what you're suggesting.
I don't know how anybody can really say that until the Supreme Court comes down with a decision. And if it's going to be a narrow decision or a broad decision, we don't know. And then how that gets interpreted is still up for question. So anyone that really says, oh, it's not that, it's just this, very narrow, no one knows. And so we have to consider all the possibilities and be ready for, whatever the U.S. Supreme Court actually decides.
Bob, if this case doesn't go your way, what are some of the voting laws that could change beyond the redistricting issue?
Well, imagine, Jack, that you might have a federal election, Senate, Congress, president, that's only on Election Day, no early voting, that a very stringent voter ID is required. We don't know exactly what the voter ID law will look like, but this could be a very extreme kind of voter ID, that purging voters may be opened up in ways we haven't seen, the end of same-day voter registration. A lot of the things that have been passed by the North Carolina General Assembly that voters have come to expect and utilize in the last 10 years plus, that it really, in our mind, has increased voter turnout, they could be eliminated for these federal elections. And I know one of the former State Board of Election directors has said it would be chaos trying to administer such.
The two Republican leaders who are the main applicants in this case, that's Senate Leader Phil Berger and House Speaker Tim Moore, they've had other views on redistricting reform in the past, and you've actually been on their side, correct? Tell me about that.
Absolutely. When they were out of power, they both individually sponsored good redistricting reform bills a half dozen times, each of them. And they were, once upon a time, the party that was leading the fight for redistricting reform. They believed in it. And as the saying goes, if it was good then, why isn't it good now? Contrarily, Democrats, who now unanimously are for redistricting reform, when they were in power, they wouldn't move any bills. So yes, Common Cause North Carolina, we stood shoulder to shoulder with Republicans in North Carolina when they were the proponents for redistricting reform. I always invite Speaker Moore and President Pro Tem Berger to come back home and, return to what they once believed in. Because honestly, reform, a better way to draw the lines, would be good for everybody. The pendulum swings back and forth, and one day Republicans may find themselves out of power. And would they want the Democrats to do to them what they've done to the Democrats? Would they want to face a state Supreme Court that would no longer be there for them to challenge Democratic drawn maps? And that's what we always try to remind them of, and that we ought to come together and try to pass meaningful, comprehensive redistricting reform. That's the only way out of this mess.
So what does all this look like on Wednesday? What will your group be arguing before the court? What does that look like?
The checks and balances, the dismantling of that and the danger of that, and the fact that in the framers writing the text, the practice, the president, the history of our Constitution completely goes against the logic of what the other side, I guess, the plaintiffs are trying to assert. We'll talk about the North Carolina story, I hope that does come out, the fact that we've seen historically minorities particularly harmed by bad voter suppression laws, and this kind of thing could come back. All those things are not healthy for democracy, and I know that The other side will try to make its case, but I think we have a very good case to be made before the high court, and certainly we'll see, what happens.
Now, what will you be listening for from the justices? What kinds of clues will you be listening for?
I think sort of how they get into the language in the Constitution and what the framers' intent was, and again, this danger of eliminating the checks and balances. I would suspect that will be something that resonates with the U.S. Supreme Court. They have rejected this so-called independent state legislative theory several times, and in recent times, 2015 in a case in Arizona, 2019, even in our Rucho case, where basically the U.S. Supreme Court said, and the Rucho case was a challenge of partisan gerrymandering of the congressional map out of North Carolina from 2016, the U.S. Supreme Court said, you know what, we, federal court, don't have the authority to really rule on partisan gerrymandering, but the state courts do. And so this whole, challenge it's in contrary to that ruling. I would expect and hope to hear questions regarding that.
How do you expect this to turn out based on what you've read from the applicant, what you've read from groups that have filed amicus briefs throughout this process?
And when you mention amicus briefs, there have been 45 friend of court briefs filed for our side, including many conservative organizations. The co-founder of the Federalist Society is with us on this. In my head, though, I kind of think, it could be a narrow ruling that might be against us. The murky middle, as some call it. My heart says we win, and I really have to believe and have to be optimistic that we do win. So keeping my fingers crossed, again, this is what we believe. As I mentioned, I think that this is kind of everything about what is democracy about? Who is it serving? Is it serving the politicians, the legislature, or is it serving we the people? Hopefully the latter. That's why I hope the U.S. Supreme Court and think the U.S. Supreme Court will rule with us.
What were some of the other surprises?
In terms of the
amici,
that was the big surprise, to see so many of these conservative entities and orgs come out with us. Michael Ludig, a former advisor to Vice President Mike Pence, is not only with us, he will be in the court as one of the co-counsels for our side. That's a surprise, too, in a lot of ways, but I respect the fact that folks are on principle, with us and not with the lawmakers here in North Carolina, who I say are really pushing this for narrow interests. They didn't like the map that they drew that was an outlier, and that's what they wanted, and I think this is ultimately what is driving a lot of this, but it has dire, big-time consequences across the country.
Well, we'll all be watching very closely. Bob, thanks for joining us.
Thank you, Jack.
We're going to take one more break, and we're going to wrap up with WRAL state government reporter Bryan Anderson. He'll talk to us about some of the outside groups that are paying the closest attention to Moore v. Harper. Welcome back to the WRAL Daily Download. Earlier in the show, Bob Phillips of Common Cause North Carolina noted the volume of outside interest weighing in on Moore v. Harper. WRAL state government reporter Bryan Anderson has been tracking those groups, and he joins us for this segment. Bryan, welcome.
Thanks for having me.
Bryan, there is a way one can gauge outside interest in a Supreme Court case beyond media coverage, and that's through the amicus brief. So for the uninitiated, what's an amicus brief and what function does it serve?
So it is a friend of the court brief, and it basically means an outside person who's not directly a party in the case can weigh in on it, basically by making a filing to the U.S. Supreme Court with their thoughts, their legal arguments. So you see advocacy groups doing this. You see political party committees doing this. You see all sorts of people wanting to get their thoughts into this case, and that's what we've seen so far.
So let's just talk volume. How many have been filed in this case, and how does that stack up to other cases? Just sort of as an indicator of interest in this case.
Well, as we're recording right now, there have been 69 different briefs that have been filed on this Moore v. Harper case. Now, there are some cases where you have 90 in the same week as Moore v. Harper is argued. There are others where you see just about a dozen or even fewer of these amicis. And basically, the important thing to note is it does reflect a lot of interest in this Moore v. Harper case. I mean, near 70 is a large number, and while not unusual, it is still pretty notable.
So who's filing?
Well, I mean, the question is, who isn't filing right now? We have Arnold Schwarzenegger, the Terminator star, getting involved in this case by weighing in. You have the Department of Justice, the Brennan Center at NYU, New York University, American Bar Association, even the Conference of Chief Justices. These are chief justices across all of the 50 states who are weighing in on this, just to basically talk about the separation of powers. So really everyone, it seems, is getting involved here.
And there have been some surprises in terms of who's supporting whom, right?
Yeah, I mean, there have been some conservative professors. There have been some other legal scholars who you might associate to be more aligned with the Republican Party, actually siding with the plaintiffs here in this case, basically saying that more is wrong and you should not have this independent state legislature theory. And these are constitutional professors like Akhil Amar, Vikram Amar, Stephen Calabrese. These are co-chairmen of the Federalist Society, which are responsible for some of these conservative justices actually being on the U.S. Supreme Court. As you might remember, under former President Donald Trump, the Federalist Society helped get you people like a Neil Gorsuch or an Amy Coney Barrett or some other conservatives. So this is an influential conservative group that's actually arguing seemingly against Republicans in this case.
Now, do these arguments actually carry any weight? Will they influence the outcome of this case?
In theory, these Supreme Court justices could and should be reading all these different legal arguments that are being presented. And one thing that is notable is in previous rulings by the U.S. Supreme Court, they actually have looked at amicus briefs and even referenced them at times in their main final opinions. So it wouldn't be unusual to see some of these amicus arguments actually make it into their final opinion. But we have 70 briefs. It's awfully hard to imagine every single justice reading every single brief.
So in yesterday's episode, which was sort of an overview of the case, your colleague Travis Fain mentioned one of the more provocative amicus briefs. I'm curious, are there any briefs that stuck out as novel to you?
I mean, one interesting one was Arnold Schwarzenegger, the former Terminator star. He was also the former Republican governor of California in the early 2000s. And he sort of talked about the importance of checks and balances as a mitigating force on partisan gerrymandering. And Governor Schwarzenegger has been involved in redistricting fights. He is very much against gerrymandering. And he made this argument that, there's gubernatorial vetoes in some states, there's independent redistricting commissions, there's public ballot measures, and it seems North Carolina doesn't have some of these other protections that other states do have. In North Carolina, you don't have a gubernatorial veto over these congressional legislative maps. You don't have a referendum going on to the ballot in 2022, 2024. You don't have these independent redistricting commissions as some have called for. So what's interesting to me is that this is a case that is going to have potential for national ramifications. Even so, North Carolina is very different from how other states do this process.
And were there any arguments in support of more that you found interesting?
The America First Legal Foundation is one. I believe it's associated with former North Carolina Congressman Mark Meadows, and he also was obviously Trump's chief of staff. And basically, this group is arguing that this is not necessarily an absolutist all or nothing ruling. You can still have checks and balances based on what Congress does. Congress is a federal government, and they can enact whatever laws they want, and the states would be tasked with implementing those federal laws. So they're saying, hey, Congress, if you care so deeply about this, go ahead. You can pass something. That's a check and balance. And really, they're saying we're not against necessarily the state Supreme Court having any oversight. We're just against them creating maps like they did in 2022 by having these independent redistricting experts make the map. So really, you could see a narrowly tailored ruling. And this group is arguing basically that it doesn't have to be all or nothing, and that their view has sort of been portrayed as too extreme than what they believe it is.
Well, lots of interested eyes on this case. Bryan, thanks for breaking that down for us. Appreciate you coming in.
Thanks for having me.
That's it for this episode of the WRAL Daily Download. Tomorrow, we'll talk with WRAL Capitol Bureau Chief Laura Leslie. She'll be in Washington at the Supreme Court reporting on the arguments. We'll also hear from Michael Bitzer. He's a political science professor at Catawba College who has written extensively on redistricting in North Carolina. I hope you'll join us. And if you missed it, be sure to check out yesterday's overview of the case with WRAL state government reporter Travis Fain. You can also find our previous coverage of the case at the NC Capitol section of WRAL.com. I'm Jack Hagel. Thanks for joining us, and thanks for listening to the WRAL Daily Download and for making us part of your morning routine. Another great way to get WRAL news is the Morning Briefing newsletter. It's a daily email with Triangle news, events, and headlines to get you ready for the day. Sign up at WRAL.com/newsletter.